Welcome. Good morning to those of you on the West Coast, and good afternoon to those of you on the East Coast, and a warm hello to everyone in between. My name is Dan Balkaran, and I am going to be your employment lawyer for the next half an hour at answering all of your questions about all things employment law. As you can see on the bottom, there's my name, Dan Balkaran, and I'm associate at Samfiru Tumarkin LLP, Canada's leading employee side employment law firm. Okay, so it's been a while since I've been here. I hope everyone had a good holidays, and I'm ready to ask some really good questions about all things employment law. Let me just check to see where those questions are. Okay, there we go. Here's a question. I'm not going to say this person's name due to the uniqueness of it. I don't want them to be identified if they don't want to. So, question is: does a non-compete and non-solicitation clause apply when the employer you signed with lays you off, or is it only effective when resigning? Well, I mean, the short answer to that is it depends what's in the four corners of the clause itself and in the contract. However, I've never seen one that is not applicable to any form of separation. So the business wants to ensure that it protects itself. The employer wants to ensure that it protects himself from competition and poaching of its clients and employees. That's the solicitation part. And so is going to on any separation. So resignation, termination, etc. And it's not clear that you haven't been terminated yet, by the way, because if you're on a layoff, unfortunately, the term layoff has a number of interpretations. What it means in employment law is that you've been sort of put in this holding pattern for a prescribed period of time, after which time it becomes a termination. And so you're not effectively terminated until that time expires or until the employer says you've been terminated. So just bear that in mind. But no, it should be effective no matter how a separation occurs, because the business wants to protect itself. But there's a difference between the two. So non-competes are, I don't want to say they're presumptively unenforceable, but they're effectively that. And the reason for that is because, let's just say you spend 20 years making widgets. You have a family, you have a mortgage, you have several kids and all that stuff. And all your experience in your working life is making widgets. And you have signed an employment contract with your employer that has a non-compete agreement in it. Well, then it fires you, and company B says, hey, come make widgets for us. Well, if you were precluded from accepting that job with company B, you wouldn't be able to feed your family. You wouldn't be able to, pay your mortgage. And this is not a good thing for society. And so generally speaking, non-competes won't be enforced unless you're, in a fairly senior C-suite type position that you have a unique set of knowledge that would be, I guess, compromised with the business, we'll say. And it has to be geographically limited in scope, the clause. So if it says across Canada, it's going to be unenforceable. But if it's, to a specific defined area, then it could be. It has to be temporally limited. So 2 years, sure, or less. The smaller in time, the smaller the geographical area, the more likely it is to be enforceable. If you start talking about 5 years across North America, there's just no way it's going to be enforceable. So bear that in mind. Non-solicitation agreements, almost always enforceable, and that's just simply you can't poach former employees to come work with you at the new business, new employer, and you can't poach your former clients. Where non-solicitation agreements can be unenforceable is where it's too broad. So I've seen several non-solicitation clauses which say you can't poach clients that you worked with at your former employer, but you can't also poach opportunities that business had. So, like warm marketing leads, for example, and that has been held to be overly broad, and that can write down the entire clause. So things to be aware of. You didn't ask all of those questions, but that's just sort of a general rundown of non-solicitation and non-competes. And as always, if you're if you have any additional questions, or this directly impacts you, you may wish to talk to an employment lawyer, you can always reach us if you need to do so. At there we go, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855. Been a little rusty now. I think it was 821-5500. I don't have a copy of the document in front of me, but it's going to pop on the screen. 5900. There we go. 821-5900. Okay. Okay, let's move on to the next question. That was a good question, though. Question from Dana. I've been with my employer for 13 years now. I was on unpaid leave for 2 months due to the vaccine mandates. Okay. After my return to work, I noticed on my employment record that my service date with the company was moved from September 2009 to November 2009. Can they change that? I mean, I don't know why it would move from a date in 2009 to another date in 2009. That's sort of unconnected to your recent layoff. I mean, the short answer is, does it matter? I mean, your start date. My apologies, I missed that. So you record that your start date was moved from date X to date Y, so September. So they moved it by 2 months, or a month and a half, or something like that. I mean, listen, does it matter? In the event that you've been terminated, your actual start, and you have a severance calculation, your actual start date is what's going to matter. And the more years that go by, it doesn't matter anyway if it's September or November. They're changing it internally for their own records. That's fine. Does anything turn on that? If nothing turns on it, then I wouldn't, it doesn't matter, and I wouldn't say anything. But if there's something internally in terms of your compensation or benefits that change as a result of that, then sure, you might want to inquire about it. But the employer can do anything it wants with its internal records. The question is, do you have any sort of legal entitlement that flows from that? No. I mean, it's just an internal record. But would that have a bearing on what your start date was for as far as your severance claim is concerned? No. Your actual start date, when you started, is what's going to matter, and that is fairly easy to suss out. You have a payment record of it, and you'll presumably have an employment contract that you signed, and other instantiating employment documents. So I wouldn't worry about it. Hope that answers your question, Dana. If I didn't answer your question, send a follow-up, and I'll try to address it. Okay. Why does the government say you're only owed 1 week per year if that's not accurate? It seems misleading. I don't understand the question. So if you're provincially regulated, which is about 94% of all employees in the country, you are presumptively entitled to common law severance. Common law severance is certainly more generous than 1 week per year. However, you can choose to contract out of your entitlement to common law severance, which is sort of the most generous, other than a specific contractual term, the most generous severance you can get. You can contract out of it into anything you want, but the employer is going to exploit its superior bargaining power over you at the time of contract formation, i.e., you want the job, employer wants to limit its liability, so it says here, sign on this dotted line limiting our liability as against you in the instance you get fired. And just as an aside, always remember that the employment contract for 99% of you is not for your benefit, it's for your employer's benefit. So bear that in mind. I've had many clients say to me, I didn't have an employment contract, so I forced my employer to give me one. And I'm like, well, why would you do that? You've just completely hamstrung your legal entitlements. So if you don't have a contract, great, enjoy the uncertainty, and before you sign one, talk to an employment lawyer like myself or anyone who does employee side work. So anyway, as I was saying, you have the presumption of common law notice. Your employers will often make you contract out of that into something else. Employers want to limit their liability as much as possible in the event of your termination. Once you've been fired, you're just a cost on the way out the door. So they, generally speaking, it's not about your years of service or being fair. It's about how does the employer limit how much money it has to pay to you, because it's just dead money. Okay, and so generally speaking, in the contract that they make you sign, they'll make you contract out of the presumption of common law notice into the statutory minimums, the Employment Standards Act minimums. This is again for all provincially regulated employees. Statutory minimums which are approximately 1 week per year. That's where that comes from. It's not quite. I mean, it might vary province to province, but it's approximately 1 week per year to a maximum of 8 weeks. There's a variation at the 2 to 3 year mark where it's only, you can be a 2-year and 364-day employee and still only get 2 weeks as opposed to 3. But it's approximately 1 week per year to a maximum of 8 weeks. So I hope that answers your question. If it doesn't, let me know and I'll seek to answer it. Leanne, I was terminated from my position yesterday due to a disability. I was not offered any severance. Can my employer let me go for cause because of a physical disability? Okay, so this is a very interesting question. So I'll say right off the bat, you need to talk to an employment lawyer immediately. You need to call someone. There's a lot of nuance around what you were talking about, and so speak to an employment lawyer. If you need to get a hold of us, you can do so. Again, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, so the employer can't terminate you. Employer can't discriminate against you on the basis of your disability. Okay, and if they do, they will have to. If they do, they certainly will owe you injury to dignity damages, and depending on your severance entitlement, either severance, lost wages, etc. But that's not what you're saying here. So you're saying that they terminated you for cause. So I'm just going to back up here again and just go to first principles for a second. Your only legal right in the event of your termination is severance. Okay, so once you get to severance, once you get to termination, then you get severance. Now, it is a bad outcome for society if you're thrown out in the street with no money and no job. And so the law has evolved this sort of public policy concept over time of severance to cushion your fall. So the law wants you to get severance. However, there's certain instances where an employer is legally justified in paying zero to the employee after the employee's been fired, and those are encompassed under what's called just cause. And just cause, as I said, is just a legally justifiable reason to pay the employee zero. And so, classic example of that, it's where there's been some sort of egregious conduct or an ongoing effective breach of the employment contract by the employee. And so, classic example, or we'll say there's 3 ways to get there. Number one, a single act that is so egregious that you've committed that the employer is no longer is justified in not having to pay you severance. That would be like your classic punch your boss in the face, coming to work intoxicated, steal, theft, commit an indictable offense, that kind of thing. So that's sort of the classic way to get there. Single instance of a single act that is so egregious the employer is justified no longer or not paying you severance. Second one is a series of ongoing performance or conduct failures of which the employer provides you a clear warning of and an opportunity to correct same. So that's your classic 3 written warnings and you're out. It's not quite that neat, but you get the idea. 3 written warnings, you're out. And then the third one is called cumulative cause. It's just where there's a whole bunch of different things that have happened such that the employer just said, well, you're a terrible employee, I'm justified in letting you go. The argument and the rationale behind that last one there, cumulative cause, starts to evaporate the longer an employee has been there. It's pretty hard to argue cumulative cause if an employee has been there for 20 years, for example. So what they're saying is that they are firing you for cause. So either the single act, or more likely they're saying that you weren't doing your job properly and we've given you warnings and an opportunity to correct it. You're saying it's due to your disability. They're saying, we've had cause to let you go because of these ongoing performance failures. Most likely, I'm reading between the lines here, but that's what I assume has happened. The rub is going to be, were they aware of the disability, and was the performance failure due to your disability? And so it's not no, they can't terminate you for cause because you got disabled, that you had a disability, or even worse, because you became disabled while you were working for the employer. And so because of these nuances, as I said earlier, you 100% need to talk to an employment lawyer. You need to do it right away. Give us a call again, 1-855-821-5900. But you can't. You need, of all the people I've talked to today or answered questions from today, you absolutely need to talk to an employment lawyer so you have the benefit of legal advice around these serious questions and that you're raising. So, Leanne, I hope you do that right away. Okay. I hope I answered your questions, Leanne. Question from Tim. Employers recently told me that my shift will be changing. I was working 5:30 to 1:30, but now they want me to work 8 to 6 or 8 to 4. Can they just change my shift like that? Well, yeah. I mean, the short answer is that's not that big a change. If you have a specific reason why you can't do that they're aware of, and I've been involved in cases like this, it gets a little bit tricky. If you have family commitments, or more specifically, child commitments, child care commitments, or something like that you can't break, you might get the protection of the family status section of the Human Rights Code. In which case, you'd want to advise your employer right away. I can't do this. I have child care obligations. You may want to talk to an employment lawyer first and get a little more nuance into that, and then provide them. The lawyer can help you with the nature of the email that you're going to send to them. You want to have a written record of this because you certainly, if it push comes to shove and you say no for my childcare reasons and they fire you, you certainly got an option of human rights damages under the family status heading. If not, like I had a case once where my client had multiple part-time jobs and she'd had them for many years, and job A was aware of her commitment to job B, and so they then said, well, we're going to change your schedule to conflict with your. They wanted her to quit basically, and to conflict with your schedule of job B, and of course. We said, well, no, you were aware of this the whole time. She made you aware of it. It's constructive dismissal. Where there would have been a problem for her, and the employer didn't think of this, is if they had provided her just written notice in advance, commensurate with what her severance entitlement would have been in the event of a termination. She would have been, common law notice ahead of time. She would have had no case at all, but they didn't. So she did. So things to think about in your case. I mean, honestly, Tim, they're changing it from 5:30 to, they're changing your shift by, 2.5 hours? Yeah, I don't think you have anything. The question would be, is that tantamount to a constructive termination of your employment? I wouldn't think so, unless you've got a really good reason as to why you can't work this change. Your solution is going to be amicable. Talk to your employer and say, hey, I've been working this shift for X, Y, and Z years. I'd really like to keep it. Is there anything I can do, et cetera, et cetera? And you don't want to, because your only solution is goodwill, and this is just good advice anyway, you want to preserve an amicable relationship with your employer as much as possible. You don't want to take the legal firm road, like this is what the law says. I mean, if you start quoting law to your employer, your employer is not going to be favorably disposed to you. So you only want to do that when you have to, and you only want to play that card strategically. But otherwise, I've seen, if the employer is happy with you and you have a good relationship with them, I've seen employers make incredible efforts to accommodate. So, your solution, I think, Tim, is why. I mean, I know your solution, or the only possible solution, and maybe it's not possible, but it's going to be amicable. But otherwise, maybe they'll accommodate you. But otherwise, sorry, there's one thing I should say, Tim. If you have a medical reason, I can't think of one from 5:30 to 8, but I certainly have encountered situations where the employer had rotation shifts and employee says, I can't work graveyard shifts anymore. From here's a medical note. Employer is stuck. That person can't work graveyard shifts. They've got to accommodate to the point of undue hardship, even to the point of hiring a replacement. So to backfill into that graveyard shift. So, I mean, again, yours is only 2.5 hour difference. I don't think you have anything, but that's why I think, if you're going to have a solution, talk to your employer, see if they can accommodate you. Okay. Thanks, Tim. Sophia's back. If my employment contract doesn't say anything about my severance entitlements, I could be owed more than what they offered you. Yeah, I mean, sure, that's what I do for a living. I bet you're not going to be able to interpret that with any degree of certainty. So if you think that your employment contract, so if you've been fired and you haven't signed a release, this is very important, by the way. Don't sign a release without the benefit of legal advice unless you're certain it's a deal you want to take. Okay, because if they've provided you with fresh value, once you sign that release, you're done. Okay, you have no claim. So, talk to the lawyer first. In your case, your employment contract doesn't say anything about severance entitlements. Maybe not. Maybe it does, though. So I strongly recommend you talk to an employment lawyer. Again, you can reach us at help@employmentlawyer.ca, employmentlawyer.ca, and 1-855-821-5900. Miranda has said, I've been told that my position is going to be eliminated from the company and told that I need to move into a lower role. Can my employer change my position whenever they like? Well, first of all, how much notice have they given you, right? So if it's going to get complicated, but have your only legal right, I keep saying this, but is in the event of your termination is severance. You haven't been terminated. Have you been constructively dismissed? So have the actions of the employer are the actions of the employer tantamount to a termination of your employment such that you can claim severance? Well, that depends on that depends on the nature of the position change, right? Like if you were the senior manager and now you're the janitor, then yeah, that's a constructive dismissal of your employment. But if you were a level 2 supervisor and now you're a level 1 supervisor, well, that's probably not, right? So it depends on how much your duties have been hollowed out. Has your pay been reduced? It's an evaluation on the facts that I can't really answer on by email. It's something that we'd have to speak about, or you'd have to speak to an employment lawyer about. But absolutely, it could be a constructive dismissal. Now, whether you'd want it to be depends on, what your severance entitlement is, flowing from that, and how much notice they've. This is the first point that I made. If let's just say you have a common law severance entitlement of 10 months. Okay, so you have 10 months of severance coming to you, but they provided you 10 months of notice that about your position change, you have no case, right? So even if it was a constructive dismissal, they provided you sufficient notice, and that's all you're entitled to at law. So lots of things in the air, Miranda, that you have to evaluate. But if the position change is one of small degree with no financial remuneration change, yeah, they can do that, and you probably don't have anything. But your only option, though, here, if you do have something, is to trigger your termination, in which case you don't have a job there anymore, right? That might not be an option that you want, but you trigger your termination and severance flows from that. But you don't want to do that until an employment lawyer assesses your employment contract to find out what your legal rights are. So, you absolutely, if you want to do anything here, you have to talk to an employment lawyer again. And it's just so complicated. The law, employment law is very, very complicated. It's very specialized. Just general advice to everyone, you need to talk to an employment lawyer if you have a complicated legal question. You got to do it. I've had many clients come to me and after they've taken action and I can't help them, or it makes it much harder to help them. They've reduced the value of their claim by 50%, for example, because of actions they took, because they didn't talk to me or a similar, an employment lawyer first. So again, help at employmentlawyer.ca, 1-855-821-5900. Okay. Linda, am I entitled to a retirement package after working for 10 years with my employer? I'm planning on retiring the next year. I want to know if I should receive anything. No. So again, I keep saying the same thing over and over again. Your only legal right flows from termination. You get terminated, you get severance. That's it. That's the four corners. Terminated without cause, I should say. It's the four corners of your legal protection. If you choose to retire, you don't get anything when you quit. You're just quitting, right? It's just when you're at a certain age and you're calling it retirement because you don't plan to work again. So my advice for you, Linda, is, so there's sort of two things you can do, which are mutually exclusive. So you need to maybe get some legal advice on this, some specific tailored legal advice. But your employer, you may be able to negotiate a retirement package with them. It won't be what you want, right? But you might be able to say, hey, I'm retiring, pay me 6 months. They might do it, but only you know what your employer is like. There are some employers that absolutely will do that, and there are some that don't want to pay you a red cent, okay? And so that's number one. That's one strategy. Number two, don't tell them you're retiring, or if you've already said that, rescind your retirement, and then but then you have to wait for them to terminate you, or you have to see if they do something that you could trigger a constructive termination on. I had a colleague once. She worked in law as well. She's not a lawyer, but knew the law fairly decently, and uh, she'd had a whole bunch of years of entitlement, 15 years or something there, no employment contract. She wanted her severance. So, and I don't recommend this to anybody, but she just stopped doing her job well. Not enough to get just cause fired, but enough to the employer at some was just like, you know what, we got to get rid of you. I mean, it was like a 1.5 year campaign though, so but she did it, and they ended up firing her and paying her severance. So, but no, if you want to retire next year, you don't have an entitlement to anything, and you want to see if you can negotiate something amicably, or you can preserve your options by not telling them that and seeing if they do something that will allow you to trigger constructive dismissal. But at that point, then you're claiming severance, and it won't be an amicable separation. We'll put it that way, especially when lawyers get involved. Hope that answers your question, Linda. JC, does the employment law apply to military employment on contract as well? That's a really interesting question. I do not know the answer to that. I don't know if you're subject to a collective bargaining agreement. I don't actually know. I mean, so certainly I've had government employees, and they'll have specific acts that apply to them, pieces of legislation that apply to them with respect to perhaps shaping their entitlements, but they were still entitled to the common law, and their employment contracts still govern. So, I mean, I can't see why it, but I also don't know, like, it depends if they're unionized or not. And I don't know if you're unionized. So I believe, I believe so, JC, but that wouldn't be the case if you were unionized and you were subject to a collective agreement, and with the huge caveat that I actually have no idea. Okay, so I would assume they're the same as government employees, but military is different. So I apologize for not having the answer to that question. I can certainly look it up for you, but I've just never seen that question before, and I'm not willing to provide you with a definitive answer because I just don't know. Mark asks, I've just been let go along with a number of other staff. They're planning on closing down the company in the next 5 years. Well, they say that, and said we're only entitled to a limited severance because of. No, it's not. No, it's not. Bigger question for you is, do they have any money to pay you severance? But the thing is about some businesses, certainly not all, but I've certainly worked for businesses where they'll say whatever to try to limit any sort of, because the employees are an expense, right? They're the biggest expense a business has, and to try to limit that. I worked for a company once that the recession in 2008 happened, and in the same meeting, the CEO said to us, president of the company said to us, "Well, we're freezing all wages for 2 years because of the recession." But then also in the same meeting said we had record profits of like $150 million. So they didn't need to freeze wages. They did it because they could, right? Because there were just no job opportunities, and where were their employees going to go? Nowhere. So they knew that, and they decided to save money. Now, employees weren't happy about it, but there was nothing they could do. And so, in your case, they're telling you that, but no, it doesn't reduce your entitlement because they have less money. The question then becomes, do they have the money to pay you? And so, you need to take, if you're being let go, you need to talk to an employment lawyer right away. You need to assess the offer they've given you. You need to not sign the release they've provided you. If you sign the release, you're in trouble. Because, or sorry, I should say you're in trouble. You have no claim, most likely, and you need to talk to an employment lawyer right away and have them assess your severance entitlement. Again, helpemploymentlawyer.ca, employmentlawyer.ca, 1-855-821-5900. One last question: can an employer, this is from Jay, force retirement at a specific age through contract? Oh, this is a great question. I think so. So the short answer is you'd think they wouldn't be able to because it's a violation of your human rights. You can't discriminate against an employer can't discriminate against an employee on the basis of age. However, law firms in Vancouver have famously, there have been cases over this. Some of them have mandatory retirement ages at 65. So I don't know where those two things meet. They seem to be competing principles. I don't see how forcing someone to retire at 65, for example, isn't discrimination on the basis of age. But the courts also want to give force and effect to freedom of contract. So the short answer, Jay, is I don't know. That's a really good question. This is actually the first time I've been stumped twice in a Facebook Live session. I don't know the answer to that question. I will find the answer. Like, you can find me. Just search my name on my firm's website. You can find me. See my email address. Send me a quick email. I'll get you an answer on that one because that is an interesting question, and I would like to know the answer myself. Okay, that's it. We got all the questions. Great questions today. As always, good to see everybody again. Again, I'm Dan Balkaran, employment lawyer at Samfiru Tumarkin, Canada's leading employee side employment law firm. Again, you can there I am. You can reach us if you need to, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900, and join us on Monday with Chris Justice. There it is, 1:30 p.m. Eastern Time. Chris will be answering all your questions, employment law, bringing the justice to you. Okay, that's it. Thanks for the questions, everybody. Have a great weekend. I will see you all in 2 weeks. Thanks.